Delighted to welcome, and would ask you to welcome, Eleanor Gregan. Thank you.
All right, so as Kevin just introduced, my name's Eleanor Gregan and I'm one of the senior solicitors at Davenports Harbour Lawyers. And sadly, at the moment, the restructuring is, I would say, about 70% of the work that our employment team is doing. And a lot of the time we see it going wrong, or employers using restructuring when probably they should be looking to deal with their employees in a different way. So today, I've got an agenda. So during today's presentation, I'm going to talk a little bit about current HR issues that we're seeing in the workplace and how you can best address those with your employees. Because is everyone here today business owners, ops managers, HR managers? Is that general nodding? Okay. So we'll talk about how to best address those HR issues. We'll talk about the alternatives to a restructure that you could potentially look at, which would be better suited for your particular position that you find your business in. And then I'll go through the process around a restructure once you've decided that it's the right thing for you to do. We'll talk about tips and traps for restructuring, and also tips for recruitment as well. Because as Kevin talked about at the beginning, I often find if you get it right at the very beginning of the relationship, the employment relationship, then some of those issues that I'll talk about will not arise. Okay. So a lot of the HR issues that we're seeing come through in the workplace stem from employees' health and well-being at the moment and the uncertainty that they're facing. So a lot of your employees will be feeling anxious about job security and pay security. So for example, lots of companies we know of have put recruitment freezes on, they've put salary increases freezes on. People who were entitled to bonuses haven't been paid their bonuses. So it's in the workplace, it's just created a lot of uncertainty. And that uncertainty tends to drip down into people's performance. So it can cause their performance to decline, which then affects the business's efficiency and operation, which is not what we want. And so the important thing to remember about employees' mental health, so I think it's New Zealand Business, they say about 1 in 6 people in New Zealand will have a diagnosed mental health issue. And so when we're dealing with, the impacts of something like COVID-19 in the workplace, those issues that those employees are facing, they're going to flare up. So it's really, really important that employers are aware of those. So the overarching obligation that employers have to their employees, I'll just talk about it a little bit, is firstly, it's the obligation of good faith, and the other really important one is to make sure you're keeping your employees healthy and safe when they're at work. So this list is sort of the signs and the factors that we see employees exhibiting, which can be a suggestion to you guys as business owners and HR managers that something might be wrong with someone in your team. So can everyone sort of think of someone in their workplace or maybe their life who's exhibiting these factors at the moment? Okay, I'm going to take that as a yes, because that's how my presentation is based. But essentially, if an employee is coming to you with these issues, it probably means that there's an underlying problem in their life that you need to be aware of and being proactive around. All right. So if an employee comes to you, or if you're noticing that those issues are present with that employee, the best thing an employer can do is over-communicate, and the worst thing you can do is under-communicate. You're never going to get sued for over-communicating, but you will get sued for under-communicating. So just when these things arise in employment, it's really, really important that you talk to your employees about it and you offer them support. So some of you may have relationships with EAP providers, and we think it is a really, really good tool for employers to offer their employees when issues arise. So some EAP providers you can sign up for a full year and it can be really expensive, but other times there's there's casual options that you can explore. And so if you have an employee who's exhibiting some of those issues, I would really recommend you think about looking to an EAP provider just to provide that extra support to your employees. So a really good tool to use in your role with your employees who are facing some issues at the moment is to think about one-to-one sessions. So a lot of the old model of performance reviews was annual performance reviews where you'd pull them and it would be a very formal process. A lot of the research in the HR area these days is showing that employees actually respond better and then perform better as a result of regular check-ins and catch-ups with your employees. So these one-to-ones, I mean, we do them at Davenports and a lot of our clients do them now, and they're really, really effective for ensuring that employers know what's going on in their employee's life. And so it means that if something's going on, you've got a perfect opportunity to deal with it. And those regular catch-ups provide you with the opportunity to develop action plans with employees. You know, where do they want to go in your business? Where do you want them to go in your business? And it allows you that opportunity to help develop their goals, which will, in theory, help your business operate in a better way. Many employers are putting in place mental health policies and procedures at the moment just because it is such an important area of the employment relationship at the moment. And a lot of employers are going the full Monty and putting in place wellbeing programs where they teach skills. Resilience is a massive one at the moment, communication and how to deal with stress. So these are all really excellent tools that you can equip your staff and your managers with to be able to better respond to workplace issues. So, as I mentioned earlier, one of the main impacts that we're seeing COVID have on employees is their health, and then that's trickling down into their performance. So I just want to talk to you about performance for a little bit, because there used to be a thinking, and I think the law used to be quite a lot more relaxed around restructuring is sometimes the most efficient way to deal with employees who maybe aren't performing the best. That's no longer the case. So if an employee is not performing, you need to deal with them by a performance management program. And surprise, surprise, the most important thing to do around that is communicate with them. And that's where we've got the one-to-one sessions are really, really useful. But the most important thing we think from a performance issue perspective is once you see it arising, don't sit on it. So if you sit on it and do nothing, and then you go and see a lawyer and say, my employee is not performing, it's been like this for months, the first question that we're going to ask is, well, what have you done about it? What training have you provided them with? What expectations have you set for them? Are they aware that they're not performing? So it's your job as employers and ops managers and HR managers to make sure that if an employee isn't performing, they know about it and they know what they need to do to then be performing in the way you want them to perform. So that's why that point is to take action. And if that doesn't work, so you feel like you've exhausted your informal process and you just think, why are they not getting it? Then we can look to take formal action, and that's where you would put a PIP in place. And probably most of you in the room are familiar with how PIPs work, but if you've got any questions about them, please do come and talk to me afterwards. Yeah, and of course, if you don't know what to do, then just ask. Plenty of resources out there. And I thought I would just mention with performance issues, if you're bringing new employees on at the moment, we strongly recommend checking your employment agreement to make sure you've got trial periods and probationary periods in them, because it can make exiting an employee who is not performing a lot easier. So far I've just talked about the negatives around performance at the moment, but especially in light of COVID and the way businesses are operating at the moment, it's important to not forget about your people who are performing really well. So to recognise them and then to reward them for that excellent performance that's happening, because that in turn is going to make your business operate more efficiently. So check in with them on that monthly basis, make sure they know that you're really happy with their performance. Thank you goes a long way. But there's also other ways that businesses can put in place in terms of recognising those employees who are doing really well. So some of you here might have very fixed bonus systems, but that doesn't mean you can't give discretionary bonuses. And from our perspective, bonuses don't have to be purely financial. So they can be something like an afternoon off that they don't have to use leave for. It could be, gold class movie tickets, although I'm not sure what the movies are doing at the moment. Giving them a parking spot in the business, making them feel really valued and important. Because now more than ever, it's really important that you keep your stars and they don't go anywhere else. Any questions around that so far? Oh, one.
Just a reminder, what are the numbers up to do your trial period? Because you've got to be an employer of a certain number.
Yeah, so the law changed in, was it April 2017, Maddie? I think so. Oh no, I think it was last year. Well, it's changed very recently, and if you have 19 or less employees, you're able to include trial periods, which pretty much allows an employer to terminate for whatever reason they want to terminate. But if you've got more employees than that at the time that your new employee signs their employment agreement, then you can include a probationary period, which still allows you to terminate due to poor performance, but it's a more stringent process that you have to follow.
Yeah. Just with the PIPs, is there any difference between performance versus the attitude? So maybe the performance is like really good,
Yeah.
but the attitude is crap. Yeah.
Yeah, so this is a very fine line between performance and attitude and when it falls into performance. So if the employee's attitude is affecting their performance in the work that they're doing, then usually you would deal with it under a performance management process. But if their attitude is really negative, but or say gossiping in the workplace or just creating an unproductive environment, but actually their work itself that they're responsible is for, then you would deal with it under a misconduct process.
I think most of us in this room, when we started our working careers, there were no such things as cell phones.
Yeah.
But everyone's got a cell phone, this is one. And I've had a situation where we're on a job, client, and my employee was busy away on his cell phone on a personal circumstance. And I know I saw signing out the week outside of Plymouth Railways, and employees were not allowed to operate their personal cell phone.
Yeah.
While staying on duty.
Yeah.
So, do you see that becoming an increasing problem?
I guess it could be, but that's where, coming back to the point I made around taking action. So if you're operating a business and you don't want people using their cell phone during the day, which is you're totally entitled to not want people to use their personal cell phone during the day, then make sure that standard is known by everyone. And then when that happens, that you can say, hold on, I sent a company memo 3 weeks ago where you were told not to do that, and yet you're still doing it. And that provides you that platform to take action around it.
So with regards to PIP, quite a common thing is, I guess, as an employer, using a formal process can have quite a negative impact on the relationship.
Yeah.
So it can come across immediately as almost adversarial.
Yeah.
Do you have any recommendations on that?
Yeah, that's why that informal performance coaching before you move to a PIP is really important. So sitting down on a regular basis and saying, look, X, Y, and Z isn't up to scratch. What can I do to support you to make sure that you are performing at these levels? And have that period of, sometimes it's, 3-4 weeks of allowing them to improve, and then coming to them at the end of that period and saying, I really wanted you to improve during this period. I've supported you by doing X, Y, and Z, which is what I said I was going to do and what you asked me to do, but I haven't seen any improvement. So I think we're going to have to move to a formal process now because you haven't improved. But as long as those performance issues have been attempted to be dealt with informally, then it shouldn't really come as a surprise to the employee when you move to a more formal process and they haven't improved. But dealing with performance issues formally, although the employee may feel you're being adversarial, you're still entitled to do it if you've given them that opportunity to improve. So it's a really hard balance of keeping your employees happy, but also you've got a business to run and it has to be running efficiently at the moment. Any other questions? Okay, I'll move on to restructuring. So, restructuring is a long process. So it's not a 1 week thing. It's not something that you can just turn up to work one day and decide I don't like the structure of my business anymore and I'm going to change it. So it's really, really important. I sort of call this the homework stage. It's really important that if you're thinking about restructuring, you do your research and you do your homework to make sure that you've got a strong and accurate business case to propose to make someone redundant. So you need to think about what changes do you want to make and why do you want to make them. And a lot of the time it's a result of something that's happened in your industry. So, many retail shops are closing at the moment and they're moving online. So it may be that that's why you need to restructure. You don't need retail staff anymore. So it's very important that you think about the driver behind the restructure and you're able to jot it down on paper, because that's going to be the case you put forward to your employees to justify to them why you no longer need them, because that's what a restructure essentially is. So as employers, we see it as, I need to restructure my business to make it work more efficiently, but all an employee is going to hear is, oh, you don't need my role anymore. I'm not important to you. So you need to be able to say, it's not that, it's from a purely business perspective, for these reasons, why your role isn't required. So yeah, this is a very important stage. So when you start thinking about a restructure, you are legally obliged to think about if there are any alternatives to restructuring. So the law is very clear that a restructure and someone being made redundant should be a last resort. So you need to be able to prove, if you've got a disgruntled employee by the end of it and they raise a PG, you need to be able to prove that you went through other options before ending up with doing a restructure. So, yep, is it actually a performance issue I'm dealing with? If so, deal with it via informal and then a PIP. Could I reduce the whole company's hours a little bit to save people's roles? A lot of companies, probably some of you did this in the room here today, but a lot of companies did this during COVID. They reduced everyone to this 80% mark, but a lot of companies found that's just a temporary fix. So it's actually, you've tried that was a temporary fix, but it's very clear I need to make a structural change. Or is it that maybe I just need employees to be doing different duties? And if so, there may be scope to do that by way of management prerogative rather than hauling everyone into a restructure process. And if you feel that you've exhausted all your options and you're really confident that no, a serious structure change needs to happen here, then that's when you're probably at the right stage of looking to restructure. All right, so the first thing to think about, as I mentioned before, is your business case. Have I got a really clear understanding of why I'm doing this? The second thing you need to think about is which process am I going to follow? So there are different processes which depend on what type of restructure you need to do. So you need to ask yourself, am I looking to make a unique particular role redundant, a particular employee who does these duties? Or am I looking to, say, downsize a group of installers from 5 installers to 2 installers? Because they are quite different processes. And so if you are downsizing, say you've got a group of 5 installers and you need 2, you need to be really confident that when you do this process, you're treating everyone equally to avoid discrimination claims. Yeah.
In terms of downsizing, so would it be fair to say that last on, first off?
Yes, so sort of. The process that you follow, and I'll come to it in a second, with the downsizing means that you can create a selection criteria of how you're going to choose who those two at the end are. And a lot of the time, length of service is something that an employer takes into account, because the employees who've been with you longer, they normally they understand the business better, they've got really key relationships that you want to keep, they've got key information in their mind that you want to keep. So definitely length of service is something that can be considered when you're downsizing.
Of course, the last person on might be the most crucial person.
Yeah, and so then you would create a slightly different selection criteria if that was what you wanted. Yeah, definitely it's something that can be considered. And the other really important piece of homework to do before you set off with your restructure is to check your employment agreements. The last thing you want to do is to be accidentally breaching contract, or that you may have forgotten about a large redundancy compensation of, say, 100K. That probably won't make the restructure worthwhile. So it's really, really important that you do this homework and check the employment agreements. Okay, so the process. So the overarching obligation of good faith, which I briefly mentioned earlier, means that you need to go into this restructure process being communicative, proactive, and treating your employees with respect, because all they are going to hear when you give them this letter is, you don't need me anymore. And so in our experience, the employers who are committed to dealing with their employees with respect, because it's a genuine process, tend to get through the process without any complaints or disgruntled employees at the end. It's those employers who aren't committed to the kindness and the respect that end up with disgruntled employees, and that's when it becomes a very litigious process for them. So just be supportive. It's difficult for employers, but it's also difficult for employees. So once you've done your homework and you've checked it with the people you want to check it with, you would give your letter to your employees setting out that business case, telling them why it's their role, or why you think you no longer need 5 of these people, you only need 2. Then the employee has a period of time where they are allowed to consider the proposal. They can get independent legal advice on it if they want, and then they would come to a meeting with you where they would present that feedback to you, and they might come up with alternative ideas to the restructure, something you might not have thought of, and you are obliged to consider that. So genuinely consider it. So if an employee has come to you with an alternative proposal, you must think about it, and if you think that won't work, I want to go ahead with my proposal that I presented to you, you need to be able to justify why you haven't taken the employee's feedback on board and changed your proposal. And so you would communicate that in the decision letter to the employee. So you would say, thank you for coming into the meeting and your feedback. You provided XYZ as feedback. We disagree with you on your feedback because of XYZ, and we're going ahead with the proposal, and your role has been made redundant. And then the last thing you need to think about when restructuring is redeployment. So that's on my next slide. Redeployment obligations are significant. So you have an obligation to redeploy your employees you've made redundant, if you can, into any vacant and available roles. So again, there's that duty to act in good faith. I'll just go through that. And you must offer them suitable positions. So just because somebody has been made redundant and there's a role somewhere else in your business that they may not be perfectly suited for, but probably with some upskilling and training they could do, then you've probably got an obligation to offer them that role. So there's a very big difference between offering and allowing someone to apply. Often we hear, oh, but the employee won't want that role. And our advice is, but if they can do it, it's up to them to say, no, I don't want that role. You have to offer it to them. So it could be different pay, they might need training, you might not think they're the best person for the job, and it could be in a different location, but these factors are all still really important for you to think about in terms of your redeployment obligations. And so that's why we say redeployment and the options that are around that should be thought about as part of that homework phase, because it may affect the way you restructure your business. If you, you may not want them to be redeployed, so you would need to think about that. Are there any questions around restructuring or redeployment while we're here? Yes.
So probably a lot of people might want to know this.
Yeah.
What is that period of time from when you're making the decision, send the letter out, to that final decision? Because, you know, sometimes employees like to drag out the process, and you know that there is a period of time you need to do it with respect, but what would be considered a standard period of time that covers both parties?
Yeah. So there's no hard and fast rule in the law, but it all comes back to treating each other with respect. So we tend to say 3 clear working days between getting the letter and then having that consultation feedback meeting. And then after that, however long you think you need to genuinely consider their feedback, maybe 1 or 2 working days, and then a decision can be delivered. But it's really important that so no restructure is the same. So for example, you know, you might have an employee who's worked with you for 25 years and you're proposing to restructure their role. Giving them the letter on Monday and having a decision to them by Friday is not going to work for that employee. They've given you 25 years of service, and I just can't see how that would be operating in good faith. So it's important that you think about each individual restructure on a case-by-case basis. But yeah, I mean, blanket rule for us at the moment, then depending on the various factors, is 3 working days between getting the letter and providing that feedback. Yes?
You take the example of what happened down in Christchurch with the earthquake, and obviously that just throws the cat amongst the pigeons like you cannot imagine. Little trying to communicate with staff, and you know, there's infrastructure and the city's crashed. So going from situations like that to say like the TY aluminium plant.
What was it, sorry?
The TY aluminium plant.
Yeah.
You know, with Rio Tinto deciding, you know, large business offshore deciding we're going to close, and then you've got the politics of that, the government wanting to try and get them to stay. And what are your comments on those sort of situations? It's probably beyond us, but if there's an overseas owner who's decided, you know, people small company will close them.
Yeah, so even though it's an overseas owner, they still have New Zealand employment law obligations to their employees. But sometimes employers make commercial decisions to skip processes and deal with the fallout if it arises. So that's obviously not my advice. My advice is always to follow the law. But sometimes businesses make decisions because it's easier for them to skip the consultation process and hope nothing happens. That's definitely not my advice to do that, but it's, you know, it comes from a direct level of what they're going to do for the business and what risk they're willing to take.
And does the law give any leniency in terms of, say, what happened in Christchurch?
Sometimes the government will say you're allowed to truncate processes, which is what they sort of did during COVID. So we weren't doing 3 working days, we were doing 2 working days, for example, because the cash loss to businesses was so massive as each day went on. But that's still got to be balanced with, this is an employee who's got employment law entitlements and rights. So you don't want to truncate it too much, because then you could end up with a personal grievance for failure to follow the right process. They do now. But no, a lot of them didn't have clauses around that, especially our Auckland clients didn't have anything like that. Yes?
Could you talk us through the 2 case studies you've got there, the Vodafone case and the Westpac case?
Yes, so the Westpac case was someone who was made redundant, and they weren't offered a redeployment role because the company decided that the role was 25 kilometres away, so they didn't have an obligation to redeploy them, and they were legally required to offer them that redeployment. It keeps coming back to that premise that it's up to the employee to say, no, I don't want that role, but thank you for offering. And then the Vodafone case talked about if an employee, you know, they may not have the training and the particular skills at the time of redeployment, but if they can be trained up into it, and so you think with training they'd be able to do it, then you have that legal obligation to redeploy them. Any other questions? Oh, one other thing I actually wanted to talk about is if you do go through a restructure process and you make particular roles redundant, then you have to be prepared for the reality that you can't rehire into that role for a period of time. So the worst thing we see happen is, clients saying, "Oh, I've got to restructure," and then a month later saying, "Oh, I'm really busy, but I don't want to hire that person back." So if you were to restructure and then to get really busy again, you have that obligation to offer the employee who you made redundant their employment. So that's something to be aware of.
Often we'll see that they come back as a high consultant.
Yeah, or sometimes as a contractor. Yeah, we see that a bit. Yeah.
There's a stand-down period though before you can?
Yeah, it's around 6 months. That's what the cases are saying at the moment. Yeah, there is case law around it, yeah. So some employers are willing to take more risk than others around that. I guess it all depends on the particular motive behind the restructure. Any questions? You can come and ask me afterwards if you would like. All right, so something that is really important to me is recruitment and making sure you get it right at the beginning, because it can really affect the employment relationship. So a lot of people now are doing psychometric testing, so job fit assessments, which is something that you can do during that process, often done between the first and the second interview, and you can look to test the particular candidate around behaviour, preferences and areas which they may need support in, and then those results might structure the way the second interview should be run. Again, hiring for fit and not for skills, so someone might have the perfect level of skills for a particular role, but if they're not going to fit within your business and the culture you're trying to create, then it's probably not going to work. Always referee check. So if you referee check and you get comments, something like, "Oh, I'm not allowed to comment on that particular employee's end of employment," or I can't talk about them, then that's probably a really big red flag that you should be aware of. And then once they are employed by you, the induction process is very important. So it's the introduction the employee has to your workplace, it's the first impression they have of you, and so if you get it right at the beginning, they'll feel really valued. And again, just trial periods and probation periods, make sure you've got them in your employment agreement. They're one of the few laws that really help employers, so I think it's really important. So take-home messages. Look after your employees' health and well-being. You never know what's going on underneath the surface for them, especially following something like the pandemic. Set them up for success. Always assume good intent. So have those regular check-ins with them. Make sure you know what's going on in their life. If you're asking them questions in those sessions, it's going to provide them with the perfect opportunity to also raise issues with you. Reward and recognise your top people. Take action when someone's performance is poor. Don't sit on it. It will only get worse. Things don't fix themselves. Plan, prepare, do your homework for a restructure. Make sure you've got a very tight business case. Be strategic and make sure you've thought about your redeployment obligations. Any questions before we end? Yes?
I just wanted to know if you could recommend any changes that people should make to their employment agreements based on COVID. Is there anything you're recommending clients do differently with their agreements now?
Not particularly. We are making sure that employers have got clauses in there that they want in the event of a pandemic or something like that around remuneration, because once we went into level 4 lockdown, nobody really knew what to do or how to pay their employees. But it's very important to recognise that you may have something written in the employment agreement, but if you were to take something like the wage subsidy from the government and you provide them with that undertaking to pay 80%, use best endeavours to pay 80%, it may not matter what's in the employment agreement because you've given that undertaking to the government that you're going to do that. So, yeah, those clauses are going into employment agreements. A lot of work from home policies are being put in place at the moment because employers are embracing that. Yeah, those are the two main changes that we're seeing to documentation at the moment.
Are you seeing many instances post-COVID of people not wanting to return to the office? They're saying, I can do my job from home.
Yes, we are seeing a bit of that, and the work from home model is built on trust, right? And so it's just the best way for an employer to respond to that is, well, first of all, you're allowed to have your employees come into work if you want them to be in work. But there are obligations around flexible working in the Act, and so if that's something your employees raise with you, then you have to be responding appropriately. But the best way to keep your employees when they're working from home is to keep them accountable, regular check-ins, doing timesheets. You know, clients and customers shouldn't notice any difference if they're working from home. Just putting those procedures in place to make sure that your customer's experience doesn't change.
If you've got a situation where you need to downsize, and you've got 3 truck drivers, you need 1. But one of the 3 truck drivers is actually away on very serious sickness, might not ever come back. But you need to go out to 3 roles and say you need only 1 of these.
Yeah, the first thing I would probably do with that situation is I would look to see how long that employee has been on extended sick leave, and I would potentially think about termination on medical grounds and just checking out what their recovery looks like. But regardless, they have to be included. They're still an employee in that role, even though they're not fulfilling their duties on a day-to-day basis.
This is my favorite 2 role. Then you go out to them with restructuring.
Yeah, and I mean, it's circumstance specific. So the first thing I would be looking at is, yeah, medical examination. Yeah.
Just a comment too around the trial period. People need to realise it's not a get out of jail free year. It's not implemented correctly. You can't use it. I just had a client contact me who received a really the same you owe us your employee $15,000 because they tried to terminate them under the 90-day trial period. They didn't implement it correctly.
Yeah.
So, meaning they got to sign it after they started working. So there's something people need to.
Yeah, absolutely. And the obligation to be communicative is still there. So if you're terminating under the trial period and the employee says, "But why are you terminating me?" you have an obligation to respond. You can't say, "Oh, it's a trial period, I don't have to respond to you." And you also can't use trial periods for new employees. So if someone's worked for you before, but you're employing them into a different role or even the same role, you can't use a trial period. And that's what Vicky's talking about when she talks about they can't sign after they've started work with you because they're no longer a new employee. Yes, so they are different. Yeah, so they fall under different parts of the legislation. A trial period allows an employer to terminate without following some sort of performance or restructure process, essentially, whereas a probation period can really only be used for poor performance. But an employer still has obligations to ensure that that employee is being supported, that they're aware that the performance isn't up to standard, that they're being given opportunities to improve, that they've been given warnings. So it's very different from a trial period in terms of the process that has to be followed. Doesn't include attitude. I would hope if you had a trial period and you had poor attitude, you would deal with that quite quickly. But it comes back to what I was responding to your question around. So if the attitude is related to their performance, then you can probably deal with it under a probationary period. But if they've just got a poor attitude but their performance is fine, you might have to be more creative, which is my favourite thing to do. Any other questions? Feel absolutely free to come up and ask any of us, this is our team here, any questions, and we're more than happy to help you. All right, thank you very much.